So glad you're here. My name is Val Ricks, and I'm going to introduce our panelists today. We should have 5. There are 3 not here, so we expect them to walk in. I believe they will be here. I think they're just behind schedule. We have 3 panelists I'll introduce, and then when they finish, if the other 2 are here, I'll introduce them. First, we'll have Devito, who has taught at Florida Coastal since 2008. Before that, he was a professor of philosophy. But he is also a parent volunteer at the Seaside Play Garden, which qualifies him to discuss remedies for harms done. He will compare contract damage rules with principles of ecology. Nick Sage, on the end, is a postdoctoral fellow at Columbia Law. His doctoral dissertation at Toronto was on the theory of contract law. In a prior life, he was a litigation associate in New York City and studied at NYU. Nick is originally from New Zealand. Expect to hear a philosophical account of disgorgement as a contract remedy. Jack Graves teaches at Touro Law School in New York, but he spent 15 years in business management and will question why we do not see damage awards for breaches of arbitration clauses. Jack is presently tasked by his school with figuring out how to teach law online, which is a side note, but a very interesting one. Okay, we'll start with Professor Devito.
Thank you. Well, my paper has gone through a number of iterations, and the titles continuously change. The paper you may have seen listed is Predation as a Contract Interest. I've sort of modified that now to being Ecology as a New Ontology of Contract Remedies. And the basic idea is that if we look at contract remedies from the lens of ecology, we get some really useful insights. We've got 7 steps here. We're down below some of the other speakers here, but we're going to talk for a moment about the purpose, basic ecological concepts, received view in the ecological context, contract law in the ecological context, feminist critiques, other critiques, and then next steps. So the overall purpose of the paper is to begin to develop the idea that contracts remedies can be understood through the lens of an ecological model. What's ecology? Well, it's the scientific study of the distribution and abundance of living organisms and how that distribution and abundance are affected by interactions between organisms and their environment. So we're going to take the concepts from this area of science and hopefully use them to better understand the way remedies work. Just to give you a little bit of high school information, a species or a population can be understood as living within a niche. And if you don't remember what a niche just describes the conditions relevant to survival of the species or the population. And here's sort of a little niche here with your friend the hawk at the top. Where it will eventually, not today, get really exciting is in the concept of modeling those niches. A niche can be described using a mathematical model, and it's going to have as many variables as conditions that relate to the survival of the population of the species. And that's just called a hypervolume because it could be more than 3 variables, and most frequently is. This is the part that actually sort of matters for this paper. We can divide niches into 2 categories: negative relationships, positive relationships. And in a negative relationship, one party is harmed. In a positive relationship, at least one is benefited, but none is harmed. And think of deers eating trees. The deers benefit, the trees are harmed. They're usually not killed, but they're harmed. Or anemones and clownfish, where they're both benefited by their relationship. And there are many different kinds of these. In terms of positive relationships, we can divide them up into 3 categories, and you may know them by different names if you know ecology. Commensalism is one species is benefited by the interaction while the other is not harmed. So I'm benefited, you're not harmed. Cooperation, both species are benefited by the interaction, and now we switch and we talk about obligation, but the interaction is not obligatory. Mutualism, both species are benefited, so it's just like cooperation, but here the interaction is obligatory. Negative relationships, include competition, predation, and antibiosis. Competition is where two or more species exert negative influences upon each other through resource exploitation or interference. Predation, well, we all know what that is. One species feeds on the other. And antibiosis talks about one species inhibiting the activities of another. And we're really going to focus in on these a bit in the paper today and try to put some remedy stuff into that context. So what do I want to do now? I've sort of lived out the basic concepts. To introduce the approach, I'm comparing it to something all of you should have either remembered or forgotten from your first year contracts class. Fuller and Purdue's views on contracts interests. So we'll have restitution interests, reliance interests, and expectation interests. And the idea of a restitution interest, according to Fuller and Purdue, is to disgorge this unjust enrichment. For reliance interest, it's to return the parties to their pre-contract position, and expectation is to put the parties in the executed contract position. When you look at that paper, it's actually, most people only get a little slice of it, but if you walk through the entire thing, you'll notice that there are a variety of focuses that Fuller and Purdue put on resource distribution. They'll talk about the economic model. They'll talk about the Aristotelian view of justice. And then they'll talk about the real contract, which is something like action for the price. What I would say is that that sort of discussion is simply another way of talking about an ecological relationship. If you remember, a niche, going all the way back here, is how these various variables are distributed in a population. Well, if you're talking about these kinds of resource distributions, then you're talking about a niche, or at least something that's very similar to an ecological system. Well, let's talk about it a little bit more in depth. The restitution interest is the interest in avoiding predation. What does restitution involve? It involves a combination of unjust enrichment, unjust impoverishment with unjust gain. And think of that as a negative relationship. One party is harmed. I think that this is really talking about predation, feeding upon one another. Now, we have to be careful. Predation doesn't necessarily mean just feeding on and killing and consuming the other entity. That's standard predation. But you can talk about herbivores where the plants are not necessarily killed, but they're injured. So the cow eating the grass, the deer eating the tree. And then we can also talk about parasites, which depend on the host for resources. And usually that's not to the benefit of the host. So we don't have competition here because there's not mutual inhibition, and we don't have antibiosis where one party inhibits the other. What's really going on, I think, in the restitution interest is predation. When we skip over to expectation interest, we have an interest in avoiding antibiosis. The expectation interest compensates the injured party for loss of opportunity to enter into other contracts. Well, that's a negative relationship where one party is harmed. And Fuller and Purdue see the expectation interest founded in the creation of an inability to act. So to take on another opportunity is central in their view to the expectation interest. And that's just straight up antibiosis. We could try to argue that it's a form of competition, but I don't think that quite works here. The reliance interest, that's going to also be about avoiding antibiosis. Reliance requires injured party to change its position, so it's creating a loss in that action. And that's, once again, a negative relationship. And this is another form of taking action that does not give benefit to the other party, but instead limits what they or you cannot do. And therefore, I think it is another form of antibiosis. So that's a sort of talking about Fuller and Purdue. If you look at Fuller and Purdue, I think you can recast them in the ecological model. I think we can also talk about contracts law in general and see that we also see ecological concepts there, because when you look at it overall, and I haven't in this presentation done the entire universe of contracts law, I think you can see, though, that it favors or disfavors negative ecological relationships. What I've done relatively simply is to talk about enforcement and formation. When you look at contract formation, you're going to see that contracts law is at best neutral with regard to positive and negative relationships, but contract enforcement is not. So formation, you've got things like mutual assent and consideration. In mutual assent, the courts don't take into account whether the parties made a bad bargain. If you're getting harmed in some sense, the court doesn't care. Similarly, when you talk about consideration, you can talk about exchange of benefits, exchange of detriments. And there are cases where parties are both exchanging detriments. So you've got a situation formation where you've got a perfectly legitimately formed contract in which both parties could be benefited, one party benefited, the other not benefited, both parties harmed, one party benefited, one party harmed. It doesn't care for the purposes of formation. But then when things go wrong and you go to the courts for enforcement, it does care. And I've only got a couple of simple examples here. Infancy, when we talk about the infancy or minority rule, what's the purpose of that? Well, the purpose is to protect children from unscrupulous individuals seeking to profit from their youth and experience. In essence, we're attempting to protect them from these bad bargains. We also have to worry about fraud, which is just simply an undue and unconscientious advantage taken of another. So once again, these bad bargains where one party is harmed are unwound. And then when we talk about mistake, you can have an unexpected material imbalance. And what I argue is that each of these, and you can expand on these for most offenses, seeks to avoid a negative ecological relationship. All right, so the paper jumps to a variety of topics. The next topic is feminist critiques. And the reason I jumped to a bunch is I'm trying to sort of lay out the idea that ecological models are a plausible way to talk about contracts and remedies. And to do that, I want to sort of attack a variety of different areas. So I also talk about feminist critiques. So this is feminist critiques in general of contracts law. If you take a look at many feminist critiques, and I look at about 4 or 5 in the paper, you'll see that they adopt a notion of oppression, or at least you can see a notion of oppression within them. And that's a set of systematic restrictions on the behavior of Group A, which will be women, imposed by Group B, men, where those restrictions are unjust or imposed without adequate concern for the interests of Group B. That's intended to secure benefits for Group B at a cost to Group B at a cost to Group A. And it's rationalized according to the features of the groups that differ. Now, there's a lot in there, but when you look at that, a big chunk of that is a negative interaction problem. You've got sort of predation or any other kind of negative relationship imposed by men on women. I then draw this down and I look at 4 different feminist discussions of contracts specifically. So we talk about contracts textbooks, contracts curriculum, contracts in practice and market transactions, contracts in theory. What I argue is that each of these expresses the view that contracts law is oppressive. Once you've got oppression in there, you can hop back and say, well, oppression is really negative interaction, so these are each actually, in some sense, an ecological argument, or at minimum, consistent with an ecological argument. When you look at contracts critiques of Fuller and Purdue, generalized ones, so here are feminist ones, here feminist in general, these are Fuller and Purdue in specific, and I've only got a few in here. I think you can recast them as making similar arguments. Barnes and Zalesny, and I'm very bad at pronouncing names, so if I've mispronounced anybody's name and you were in the room, please explain that to me. They recommend restructuring the expectation damages rule and eliminating the reliance damages rule, and they replace that with the concept of a surplus. The surplus is linked to the concept of both parties benefiting from the contract. Well, if you think about that, if the concept is both parties benefiting, what you're really talking about is cooperation, where both parties are benefited by the interaction. Kelly, so we're going to talk about Kelly. Fuller and Purdue really talk about 3 reliance measures, and we've got pure reliance interest, the reliance limited by expectation interest, and the expenditure measure. When you look at these, you're going to see that they fall in, and we're running out of time, so I'm not going to go through these in depth, or at all actually, but you're going to see that these all can be recast in the concept of the ecological model. Sometimes it's a bit of a stretch, but I think you can do it for all of these, and I'm not going to go through Kelly just because Kelly's a little long. Restoration remedies are where the injured party in a transaction to which one party is breached is put in a position similar to the one she would have been in had the parties made and performed a contract in which their obligations were adjusted to the actual performance. So I'm supposed to send you 1,000 red bicycles. I only send you 750. What we do is we act as if the original contract was just 750 red bicycles. and we adjust. When you look at this, it looks like it's neutral in regard to negative and positive ecological damages because the idea is to maintain the balance. Of course, that's important because it is talking about balance of resources. I think, and this is on the next one as well, I suspect that if we look deeper at this, and I have not done this thus far, we're going to see ecological relationships at work. If you look at Article 50 of the UN Convention on Contracts for the International Sale of Goods, it has a variety of restoration remedies. And if we look at the purposes underlying them, I think you're talking about purposes that can be recast in the ecological model. We're running a bit out of time, so I'm not going to go into that too much depth. All right, what are the next steps? I think that I've argued, and in the paper I've done, it's in much more detail, that we can recast remedies into an ecological model. There are a lot of advantages to this. One, if we've done that, we can utilize a variety of models from ecological science to reanalyze what's going on in contracts law. I think it also gives us a much nicer metaphor when we're talking about contracts than, say, the economic theory. When we're talking about predation or cooperation, people can understand that in a much more intuitive sense than they can many of the economic theory models. So what are the next steps? Well, once this paper is finalized, sent out, hopefully accepted, I'm going to take a close look at restoration damages and try to argue that they fall within the ecological model. After I've done that, I'm going to expand out and see if there are actual remedies that don't fall under Fuller and Purdue, but that will fall under the ecological model. Then examine the usefulness of ecological models for gaining insights into contract law and compare and contrast the ecological model with other models like the economic models. And finally, look at a historical analysis. You can see this is a fairly extensive research project. That's it. Thank you. Thanks.
Okay. Well, thanks to everyone for coming early on Saturday morning. It's a pleasure to be here, and thanks to everyone at St. Thomas who's been doing such a great job organising this conference. Today, I'm going to talk about a problem that I'm working on which is, as I see it, at the intersection of contract and property law. This is the problem of when to award a disgorgement remedy for breach of contract. A disgorgement remedy is a remedy that strips the defendant contract breaker of profits made from a breach of contract. And because we just heard about the three contractual remedial interests that Fuller and Purdue talk about, I just should distinguish disgorgement from the restitution interest, or what I'll call the pure restitution interest, which Fuller and Purdue talk about. Pure restitution is when a plaintiff confers some benefit on the defendant under the contract and then seeks to get that benefit back. Disgorgement is different, right? Because the benefit that the defendant receives, which the plaintiff wants to get, need not have been conferred on the defendant by the plaintiff. It can come from a third party. And I'll give you some examples of cases which should hopefully make that clearer. And I'll start with one now, because to introduce this problem, the problem of when to award disgorgement damages for breach of contract, I'd like to start with a short story about a spy who betrayed his country. George Blake worked for MI6 during the Cold War. MI6 is the English equivalent of the CIA. It's who James Bond works for, right? So George Blake was meant to recruit Soviet spies to set up a network of informants for MI6, but instead he became a double agent for the Soviets. So he was caught eventually, and he was sent to prison in England. But he escaped, apparently using a ladder made out of knitting needles, and he made it all the way to Moscow. Years later, still in Moscow, he writes a memoir about his career as a spy, which is published in England. That publication is contrary to the employment contract that Blake had entered many years previously with MI6. He'd promised not to publish anything about his career as a spy. So the UK government sues Blake for breach of contract. And as a remedy, it seeks to get the profits that he's making from the publication of this memoir. And the highest court of the United Kingdom agrees that this remedy is available. It holds for the first time that disgorgement of profits is an available remedy for breach of contract. So what's the problem? Well, in this case, the court says that disgorgement won't be available for every breach of contract. It'll be available only in limited circumstances, in some cases. But at the same time, the court says almost nothing about what those circumstances are. So the problem, or the challenge, is to explain precisely when disgorgement should be available for breach of contract. And I've introduced this using an English case that was decided in 2001, but this is a problem for common lawyers the world over. In the United States, as of 2011, the third restatement of the law of restitution and unjust enrichment recognizes for the first time in a sort of authoritative source like that, that disgorgement is also an available remedy in the United States. Okay, so I said at the start that I see this as a problem at the intersection of contract and property law, but so far I've only talked about contract. Property law comes in by way of contrast. Where a defendant profits from a breach of property rights, for example, through a trespass or conversion with respect to some object of property, disgorgement doesn't seem difficult to explain. It's simple. Whenever I profit by wrongfully using something that belongs to you, you can get the profits that I make from doing that. If I wrongfully use your car or your house, or if I sell those things to a third party for a profit, you can get disgorgement. There doesn't seem to be any difficulty explaining what's happening here. So my aim in this paper that I'm still developing is to explain when disgorgement is available for breach of contract by comparing and contrasting the property context, where things seem easier to understand. So my proposed explanation has two stages. First of all, I start in the property context and I abstract an analytic framework for determining when disgorgement should be available in general. Then secondly, I turn to the contractual context. I take this analytic framework that I've developed over to this context and I ask, why is it especially difficult here to explain when disgorgement should be awarded? Okay, so stage one, this is the property context. To bring out the structure of the disgorgement analysis here, I use a famous case. It's an American case. It was decided in Kentucky Court of Appeals in 1939. It's called the Kentucky Cave case. And this is a leading authority on proprietary disgorgement throughout the common law world. So in Kentucky, there are lots of limestone caves, which tourists pay to visit. They're very impressive. I've visited some of these caves myself. Mainly because of this case, I'm ashamed to admit. So in the Kentucky Cave case, the defendant makes money by showing tourists through one of these caves. Now, the entrance to this cave and a large part of its interior are on the defendant's property. But it turns out that other parts of the cave's interior are on the plaintiff's property because the cave goes underground across the boundary line, right? So the plaintiff sues and the court awards disgorgement of the profits that the defendant's making from the tourists. But of course, the court doesn't award the plaintiff all of the defendant's profits, right? It only awards the portion of the profits that's attributable to showing the tourists the plaintiff's part of the cave, not to showing them the defendant's part of the cave. That makes sense, I think. And from that, I take a very basic structure for the analysis of disgorgement. We need two things. On the one hand, we need a description of the plaintiff's relevant rights, such as a right to part of a cave. On the other hand, we need a description of the defendant's profit-making action, showing tourists through various parts of the cave. For disgorgement to be available, those two descriptions must coincide, right? Which is just to say that disgorgement is available only to the extent that the defendant's profit-making action is itself contrary to the plaintiff's rights. So that may seem staggeringly obvious. It is in a way, but I think it gets overlooked all the time. And I think my formulation there actually differs from existing treatments of proprietary disgorgement in the literature. I also have some thoughts about the normative basis for this framework, why disgorgement should work on this basis. But hopefully the framework itself is relatively clear, because now I need to move on to the second stage of my argument. So stage 2, now we turn to the contractual context. So what makes this different so that disgorgement is available only in limited circumstances? To give you an example of a contractual case denying disgorgement, consider Acme Mills and Johnson. This is another Kentucky case this one's from 1911. So Johnson was a farmer who contracted to sell 2,000 bushels of wheat to the Acme Mill at the end of the harvest. But the price of wheat rose in the interim, and at the end of the season, Johnson sold his wheat to a third party for a higher price. The mill sued for breach of contract, and it sought to get the profits that Johnson made from that sale, but it failed. The court denied disgorgement for this breach of contract. So why is disgorgement denied in a case like this, but awarded in other cases, and why is it especially difficult to see when it should be awarded in the contractual context? The difference between the proprietary and the contractual context, I suggest, is that contractual rights vary in a way that property rights don't. Contractual rights vary in what we can call their logical scope. So what do I mean by that? Well, there are 3 possible variations in the logical scope of a contract right. First, a contract right may be particular. For example, if we agree that, as between me and you, this particular chair right here is yours. Second, a contract may be exhaustive. Contract right may be exhaustive, by which I mean a right to all instances of a type of thing. For example, we might agree that you have a right to all chairs with black arms and red fabric covering. The right is exhaustive there because it covers all instances of the specified type. Third of all, a contract right might be neither particular nor exhaustive. That is, a right to only one instance or a number of instances of a specified type. So if we agree that you have a right to a chair with black arms and red covering, or 3 chairs meeting that description, your right's neither particular nor exhaustive. So I can make this distinction in the logical scope of contract rights, but you say, so what? Why do we care? Because, according to stage 1 of my argument, we need to be able to say that the description of the plaintiff's rights, on the one hand, and the description of the defendant's profit-making action, on the other, coincide. And in general, that's possible if the plaintiff's right is particular or exhaustive, but not if it's neither. So if you have a right to this particular chair, and I profit by wrongfully using or selling this particular chair, my profit-making action and your right coincide. So my profit-making action is itself wrongful, and you can get disgorgement. Likewise, if you have an exhaustive right to all chairs of this type, and I profit by dealing with one chair of this type, to that extent, my profit-making action, dealing with one chair of this type, is contrary to your right to all chairs of this type, right? But contrast if your right is neither particular nor exhaustive. Say you have a right to a chair of this type, and I profit by dealing with a chair of this type, or 3 chairs of this type, or however many chairs of that type. Now we can't establish that your right and my profit-making action coincide, right? We can't say that my action is itself wrongful, and so there can be no disgorgement. So I think that this is a very abstract way of describing exactly how the disgorgement case law plays out throughout the common law world. So disgorgement is available for breach of a particular right. So the classic example is if I sell you a particular house, then before you take possession, I purport to sell it to a third party for a higher price. You can get disgorgement of the profits I make by doing that. Disgorgement's also available for breach of exhaustive rights. So for example, if I promise to acquire all shares of a certain company for you, but I profit by wrongfully selling some of those shares to a third party, you can get disgorgement of the profits I make by doing that. But disgorgement's not available if the right is neither particular nor exhaustive. And this is just the Acme Mills case that I talked about before, right? So there the mill had a right to some instances of a type of thing, had a right to 2,000 bushels of number 2 grade wheat. The farmer profited by selling a bunch of instances of that type of thing, but you couldn't establish, it's not necessarily true that the farmer profited by selling the wheat that belonged to the other party under the contract. So there's no disgorgement in that kind of case. So I think this variation in the logical scope of contractual rights explains why disgorgement is harder to understand and is available only in limited circumstances for breach of contract. Contrast the property context, where disgorgement isn't limited. The classic property right is a right to a particular object, like this chair, or this car, or this house, or this part of a cave. Intellectual property rights, where disgorgement's also commonplace, are generally exhaustive. For example, a patent right is a right to all instances of a type of invention. One last point. So I've explained this logical scope idea by talking about descriptions of physical objects like chairs or cars or caves or wheat, or conceptual objects like inventions. But the logical scope distinction applies to anything we like. We can, for example, apply it to contractual rights over actions or services. So say that you promise me you'll write a memoir about your career, a typical positive covenant of an action. We've described a type of action here, you writing a memoir, of which there can be potentially many instances. You've promised me one instance of the type, so my right is neither particular nor exhaustive. Therefore, if you write a memoir for somebody else, for some other publisher, for example, I can't get disgorgement of the profits you make. I can't say that that action is itself wrongful. So this applies generally to most positive covenants for the performance of an action or a service. Disgorgement's not available. But contrast where you promise me that you will not publish a memoir about your career, a so-called negative covenant. Here my right is exhaustive. Any instance of you publishing a memoir about your career is itself wrongful. So if you do go and write a memoir for somebody else, I can get disgorgement of your profits, which is, of course, what happened to George Black. Thank you.
All right, good morning. I think we could start with the title itself in some ways says it all. My guess is that for most of you, the title Damages for Breach of an Arbitration Agreement either comes across as obvious, of course, there's a contract, there's a breach, the aggrieved party's entitled to damages. Or in contrast, it comes across as completely outrageous. If a party supposedly entered into an arbitration agreement, surely it should be able to go to court and ask whether that arbitration agreement is binding, and if not, at most be compelled to arbitrate, but surely not to pay damages. My hope is by the end of this quick talk to be able to convince you that while not entirely obvious, the idea of damages for breach of an arbitration agreement is in fact far from outrageous. Our starting point, just because we're shifting gears a little from typical contracts to arbitration agreement, is it's important to remember that an arbitration agreement is enforceable just like any other contract. We've heard that quoted by Justice Scalia in I don't know how many Supreme Court decisions, sometimes to our chagrin, sometimes perhaps less so. A contract for arbitration is also separable and autonomous, even when contained in a main agreement, for example, for the sale of goods or for provision of services. The arbitration agreement is always treated as a separate and autonomous contract. The party to an arbitration agreement, and this is certainly not rocket science, has really two different sets of rights. One, a right to stay conflicting court, or a request to stay of conflicting court proceedings. And two, a right to compel arbitration, including, as necessary, the appointment of arbitrators. The FAA, however, is less clear. In fact, it says nothing on awarding damages. It says nothing precluding an award of damages, says nothing providing for an award of damages for any breach of the arbitration agreement. Thus, we are presumably left with contract damages. And it's important as I talk about damages for breach of an arbitration agreement, again, it may seem obvious, but it's important to remember we're talking about something completely separate from the damages arising from the merits dispute, which was purportedly subject to arbitration. So again, very different set of damages for the breach of the arbitration agreement itself. And if this is reasonable, the question I'll come back to at the very end is, why don't we see the issue more often? There's virtually nothing written on this by way of commentary. There are very, very few cases addressing the issue. And again, I'll come back and talk about the possibilities as to why that might be. The problem with arbitration, in fact, I think almost certainly for commercial arbitration, the single business-to-business arbitration, the single biggest problem is that a party that is seeking to simplify, speed up, and reduce the cost of dispute resolution suddenly finds itself with two disputes instead of one. And certainly that is of no, well, that may benefit the lawyers in terms of billable hours. It certainly doesn't benefit the client. The client who wanted to make dispute resolution easier has made it much more difficult. In fact, most businesses will tell you this is their biggest single downside concern when they think about arbitration. The arbitration agreement clearly includes a positive promise. We'll arbitrate disputes within its scope. In fact, some arbitration clauses actually go so far as to include an express negative promise, and we won't go to court for any purpose other than in aid of or furtherance of the arbitration process. But even where there's no express negative promise, generally we imply a negative promise. The positive promise to arbitrate disputes implies a negative promise, and we won't take those disputes to court. So the FAA, through specific, something akin to specific relief, gives effect to both promises. The positive promise is given effect through through a petition to compel arbitration under Section 4, and if necessary, to appoint an arbitrator under Section 5. And a party has a right to enforce the negative promise through a stay of conflicting court proceedings. And I say a stay only because the court typically retains jurisdiction in order to confirm an award or entertain an action to vacate an improper award. And in fact, specific relief is perfectly logical in this context because arguably if the party who bargained for arbitration never got to arbitration, the damages would be incalculable. You know, how might the arbitrators have handled this different than a court? You know, it's classic. Damages would not be sufficient to remedy the breach. But we also know that specific relief, whether in the context of arbitration or a sale of goods or provision of services, specific relief doesn't necessarily eliminate damages. It may reduce damages, but it doesn't necessarily eliminate damages, and it certainly doesn't preclude an award for damages that are suffered notwithstanding the specific relief. So, in the case of arbitration, even if a court stays an action that was brought contrary to the arbitration agreement, the breach of the arbitration agreement will still very likely give rise to two kinds of damages. One is the attorney's fees incurred in the litigation in violation of the arbitration agreement. And I'm not talking about fee shifting contrary to the American rule. We're not talking about the attorney's fees spent in the agreed upon arbitration proceedings. Only the attorney's fees spent in the litigation which was in breach of the arbitration agreement. Easy to quantify, no problem. In addition, there's the additional cost associated with the client's burden in maintaining two sets of litigation, and in dispute resolution, and in the delay resulting from the detour to court proceedings. Now, this, in contrast, is really going to typically be very difficult to quantify. In fact, I think it's a perfect candidate for a liquidated damages provision. The agreement itself, the arbitration agreement itself, almost certainly, if it's well written and it has a broad scope provision, it almost certainly deprives a court of the ability to award damages for a breach of the arbitration agreement. No question. On the other hand, if broadly written, it should confer that power on the arbitral tribunal, assuming that you've got a broad clause, anything related in any way to this contract, any dispute related in any way to this contract, including its arbitration agreement, that certainly ought to grant the arbitrators the power to award damages for a breach. So we've got there's not many cases, but there's an interesting one from Texas, 2013. D.R. Horton, Texas versus Drogzeth. And the case itself was a garden variety action to compel arbitration. The Drogzeth sought to avoid the arbitration by arguing unconscionability. Again, most of her unconscionability arguments we've seen, we've read, the U.S. Supreme Court has rejected virtually all of them. But the one that was the most interesting was that she argued that the arbitration agreement was unconscionable because it included a $10,000 liquidated damages provision payable in the event of a breach of the arbitration agreement. Now, the court dodged the issue. The court dodged the issue by assuming, without deciding, that this provision was unconscionable, and saying, but it really doesn't matter because when Horton tried to, or moved to compel, expressly waived the right to enforce the liquidated damages provision. Moreover, the court said it doesn't get her out of arbitration because we can always sever it from the arbitration agreement. But even when the court assumed, for purposes of argument, that it might be unconscionable, it focused on what it described as its penal nature. Court never suggested that a proper liquidated damages provision as opposed to a penalty would necessarily be unconscionable. Interestingly, and this is a bit of a side issue, but it's also important, the question of whether it was a valid arbitration agreement was decided by the court, but in fact the arbitration agreement provided for AAA construction rules, which include what the U.S. Supreme Court now calls a delegation clause, that essentially said that jurisdictional issues would be decided by the arbitrators. Now, whether the attorneys just didn't pick it up or not, I don't know, but in fact the question of whether, and Renner Center tells us that this includes the question of unconscionability. So this issue of whether or not this fixed sum damages provision should have been enforceable, should have actually been decided by the arbitrators, not by the court. Which leads me to the question, why shouldn't an arbitrator award damages? Why would this be unconscionable? Now, presumably, I think most people say, but wait a minute, this isn't fair because it's unfair to award damages for a party simply who doesn't know whether they're bound by the arbitration agreement. Shouldn't they be able to go find out without having to pay damages? And that's a fair question, except parties face that all the time in breach of contract cases. Lots of times, parties genuinely disagree as to what the contract requires. They each go forward and perform as they think appropriate, and a court eventually says, you were wrong, and you pay damages. So again, I'm not sure that really distinguishes it from any other sort of garden variety damages case. Moreover, U.S. courts have actually been pretty regularly granted damages for breach of an exclusive forum selection clause. I'm going to skip the West Tankers case and the international one. I'm happy to talk about it later if somebody's interested. Is a damage claim desirable? Well, it used to be, before the FAA, one of the ways parties got their counterparties to comply with arbitration agreements is they actually had penal bonds. I suspect that a court wouldn't enforce one of those today post-FAA. Again, it's a penalty even if you've got to unwind it. I'm guessing that that's not going to be very effective. So I don't think you can penalize a party into complying with an arbitration agreement. On the other hand, a lack of a damages remedy arguably undercompensates the breaching party and therefore encourages breach. And we all know that justice delayed by way of a detour to court proceedings is often, and to some degree, justice denied. So awarding actual damages seems to me to be an approach that would neither terrorize a party into complying with the arbitration agreement, nor would encourage a party to go delay by initiating contrary court proceedings, and in fact, arguably would make it more likely that parties, when it came time to resolve the disputes, both complied with the arbitration agreement. I have some thoughts on drafting. I've got a model clause, but that doesn't work well in a slide, so I'll just talk about it briefly. You've got your basic arbitration agreement that include, and I would include an express promise not to go to court, an express negative promise, just to make it crystal clear, except in aid or furtherance of arbitration or as mandated by governing law, for instance, FAA sections 9 and 10. I'd include a delegation clause. Delegate the power to decide the jurisdictional issue, whether the parties agreed to arbitrate. Delegate it to the arbitrator, and as part of that, include the express authority to award damages for a breach, including actual attorney's fees and including liquidated damages, which should be liquidated in a reasonable amount. Why not? In fact, we shouldn't actually even require the express language I just suggested. You ought to be able to at least bring an action for your attorney's fees just based on a standard arbitration agreement. It's a breach of contract. Easily quantifiable, reasonably within the scope of arbitral power under a broad general arbitration provision. Thanks. So why doesn't the issue arise more often? In fact, now you might say, well, you just told us this is a decision by the arbitrators, so of course we're not going to see it in court proceedings. I can almost guarantee you that today, if a party had an arbitrator award damages for breach of an arbitration agreement, that party would almost certainly go to court under FAA section 10A4 and claim that was beyond the power of the arbitrators. There's just not enough. Somebody's going to test that. And the fact that it hasn't been tested, when everything else in arbitration is tested, suggests to me it's not happening very much, at least not in this country. It's actually more common. There's a fair number of ICC awards that do this, a fair number of LCIA awards out of London. But as far as I can tell, it doesn't happen in the United States. Why not? It seems to me that there are a couple of possibilities, and maybe in your questions I'd invite your thoughts. It seems to me one possibility, one possibility is it's the lawyers. This is the cynical view. It's the lawyers. The lawyers don't want to do that. 2 disputes is better than 1 for the lawyers. Why discourage those trips to those detours that might get me to the U.S. Supreme Court? Second one is maybe it's the parties. The parties go, you know, I'm not sure. I like the idea of arbitration, or I wouldn't put it in there. I like the idea of fast dispute resolution. But what if I'm on the respondent end? Maybe that's possible. Maybe the parties are just not comfortable with going this far with an arbitration agreement. There's a third one, which may be almost as bad as my first cynical one, and that's ignorance. I think there's a fair amount of ignorance in the practicing bar about how arbitration really works, other than it's a simplified procedure for resolving disputes. And I think that's probably why the decision in Horton versus Dragzeth ended up with the court instead of the arbitrator, where it should have. Thank you.
Introduce our other 2 panelists. On my far left, we have Katie Gianasi, who practices in Chattanooga, Tennessee at Husch Blackwell. Is that how you say it? Blackwell. Her practice is transactional. She's a graduate of Tulane Law School, where she received the Cali Excellence Award in Contracts. Wish I had done that. Her bachelor's degree, also from Tulane, was in medieval studies. And she's also studied theology formally. She will teach us about waivers of direct and consequential damages. We'll also hear, finally, from Caprice Roberts, who is at the Savannah Law School. She is the co-author of a Remedies casebook and also teaches federal courts. She's taught at least 5 law schools and has yet to reach the age of 25. And she will discuss restitutionary disgorgement of benefits as a contract remedy for opportunistic breach. Thank you. Katie?
at this point, I'm working on a paper that the concept began when, in practicing, I found that in negotiating commercial contracts specifically, where unconscionability really isn't an issue when it's two business entities and they're negotiating forms or, agreements that might get negotiated quite a bit, there was just all different opinions about where there is a waiver of consequential and indirect damages. Do you have to, within the waiver, specifically say what it does not apply to? If there is separately, an indemnification clause, confidentiality provision, and often there's just these bucket lists of words thrown in there. So even, there's a liquidated damages clause, and, even listing that it wouldn't basically, nullify that itself. And so I tried to look at cases about how this has been handled, and I didn't find as many as I'd hoped, and I'm still kind of examining what occurs, and it tends to vary based on the facts, and also, state by state, certain issues such as, in one state, even the waiver itself would extend to tort claims, even though that's not called out, and in some states, if it's not called out, it doesn't extend to those. So I've had trouble finding any sort of consistency at this point, but it really highlighted the fact that the terms themselves are problematic. They're being used to, in some cases, refer to remote damages that wouldn't be recoverable anyway, but in other cases, there's a little bit of hedging as to how would this really play out, but the court is actually going to look back at what the parties intended. And, in a lot of cases, you might have caps on the damages as a whole that kind of make some of the issues moot, or, limited remedy provisions. But there were some really interesting decisions that definitely made me kind of rethink how these clauses should be drafted in forms and negotiated and kind of discussed with clients generally. Obviously, there's Hadley with, the consequential damages, if you understand that the other contracting party might suffer these damages, and it wouldn't be universal. And I think that's really a hard distinction to make in a lot of sales contexts, especially when you're dealing with kind of components or, not just a finished product. That's sort of understood, but I think sometimes the parties are trying to disclaim something else, or they are including provisions in indemnification agreements, liquidated damages within the agreement that would themselves be considered consequential, even though there's a waiver. There is, in some cases, if the clause is found to be ambiguous, then the courts have looked at, kind of outside the contract. And there was one where even just sort of what the attorneys were doing and how the drafting process proceeded was examined in a way that I'm sure the attorneys wouldn't have thought, they're, trying to use the words for just the contract to stand for itself, and it really wasn't how it was being looked at. So in this one case, it was, it's hard to find really authority that would kind of give you any sort of confidence across jurisdictions. But in one case, it was found that the clear and unambiguous exclusion precluded recovery of third-party claims under the indemnity. And that, again, kind of raises a lot of issues about, is the indemnity state by state understood to cover first-party claims or third-party claims if that's not specified? And they actually, in this California case, did say that the third-party claims were disclaimed by the separate, in a separate part of the contract, there was a disclaimer of consequential damages, and that they were unrecoverable for that reason. And I really don't know if that's what the parties intended. Maybe there was sort of that uncertainty on one side. But in some cases, the indemnity is mutual, so there shouldn't be any reluctance to discuss about what you're actually signing up for. But often you're working from form provisions that are either, and in some cases just a straightforward disclaimer, if it's prominent and it's held on its own, it's kind of interpreted the way it was intended, but they can get really complicated and kind of throw in the kitchen sink, and then, and there's another Tennessee case where, you know, with the confidentiality agreement, I mean, what are your remedies? I mean, are they necessarily kind of indirect, consequential? And in this case, you know, the agreement was read as a whole, and, you know, that it was clearly contemplated the availability of damages in the event of a breach, and it kind of went to the scope of damages, I think, where it could be read to make it so no damages were available, then that's the case where it more likely would be thrown out. But with the indemnity, I think there's a lot of issues with that. And let's see. You know, I think I didn't see, you know, as many cases as I thought I'd find. And I think in practice, you know, you've got either the caps or exclusive remedies that kind of make a lot of this not as important. You know, I mean, if there is a purchase price cap, and, you know, does it extend to the indemnity or not is another issue. But in examining what needs to be carved out, it highlighted the fact that with the consequential indirect damages, the parties may be better off just saying, what is it I'm trying to avoid? And is it really consequential? Because in some cases, I think it would be something that every single party would suffer in the event of a breach, and it somehow seems indirect, but it's not. And so in that case, the disclaimer actually wouldn't cover it at all. So, and, you know, in trying to define, you know, I've come across situations, you know, can we define what are the direct damages? What are the consequential damages? Which again highlights the fact that if you're talking about damages that you know might occur and you're trying to disclaim them, you probably shouldn't call them consequential if they would be recoverable under the UCC. And that in turn, you know, a lot of these kind of crossover in practice, you know, negotiating services agreements where, you know, it's kind of a different scheme anyway. So, let's see. I guess, you know, I'm sort of interested in kind of diving in more to see what I can find and try to summarize, but the point I kind of came to was that it's just going to come down to the particular jurisdiction. You know, what's the choice of law, and you know, what are the rules about whether this automatically extends to negligence or not. You know, how the indemnity is read, whether the court takes a view that it's, you know, that reading the provisions consistently means that of course it has to apply, or that why would there be this disclaimer, although it could apply to a lot that's not necessarily called out. That, you know, I don't think in practice people are going to stop saying there's a waiver of consequential and indirect damages, but, you know, even trying to dig into what the parties intend, it's kind of more, not necessarily effort, but kind of taking the conversation to a point where there is some uncertainty about what would occur, and then the reliance on caps and exclusive remedies. And I'm just sort of surprised at the amount of uncertainty I found, that there really wasn't any clear guidance other than, you know, you might as well carve out, if, you know, even if it's separately stated, whatever provisions to get an understanding of how far that provision is supposed to extend and how it works with the waiver of indirect and consequential damages, but to also consider that there might be a damage that you expected to recover that you knew, and perhaps it would be direct, that all, you know, of the non-breaching parties would suffer in a specific instance that you don't mean to carve out, or that you are throwing away more than you meant to, that you knew and that the parties understood. And then that's what's been interesting in reviewing the cases, is that I feel like the courts have been looking and saying, well, this is, you know, what were the parties trying to do, and looking at, you know, the use of the word, or not looking at the use of the word and trying to say that by not stating it, that they were disclaiming it. And anyway, so I know I've rambled some. I'm not a litigator because I'm not good at public speaking, so I appreciate your patience, but this has been really interesting for me to examine it, and basically in trying to figure out what should I be, what do I need to do to make sure this is enforceable, it just raises the issue of should I be using these words at all? In a lot of cases, if there's going to be caps on liability and there's going to be exclusive remedies, or there's the insurance provisions are kind of going to dictate anything anyway, it's not a risk that's going to kind of turn the practice upside down, I think. But when it gets litigated, I think sometimes the wrong result occurs that wasn't actually what the parties intended. So that's all.
Hi, I'm Caprice Roberts, as Val mentioned, and I'm delighted to be here again at the Contracts Conference. It's always fabulous to get back together with people whom I love dearly and to appreciate and understand actually what I'm talking about, which is nice. Not all audiences do. So I have presented any number of papers on disgorgement, and depending upon the audience, sometimes they know nothing. Luckily, you all have been well greased because you've already heard from one speaker, Nick, on this topic, so I hope to take his remarks and extend those to some extent to my work, which I haven't read his work yet, so we'll see how that goes. I'll do my best. But at any rate, to understand the topic of disgorgement, you have to understand the sort of core of contract law and the way in which there's a potential extension of that remedy in the contract sphere that's happening in the United States right now, and to appreciate that in other countries it's been happening for a long time. And the basis of that is grounded upon restitution and unjust enrichment. Those are concepts that the United States gets credit for inventing, yet it's sort of fallen out of favor here in the U.S. So not that many people are taking the course of restitution, unless you have the good fortune of having Andrew Cull or Doug Laycock at UVA. Those courses have, by and large, evaporated unless they've been subsumed in some type of remedies course or subsumed in perhaps a fiduciary duties course if it gets to that moment of constructive trust. So I'm fascinated by it because I think that the concept of unjust enrichment being laid over on top of this potential remedy for contract damages, or for contract remedy that's not damages actually, is one way that you will see in tension with the existing core of at least what the conventional wisdom on contract law is saying. And when I'm talking about that, I mean people who are adherents to the notion that you can't think about intent within contract law, that we need to think about breach in the way that the efficient breach theorists have extended Holmes in talking about the amorality and just that it's a choice between breaching or paying, and that you don't have to think about any type of willfulness or wrongfulness. Unjust enrichment inherently means that you are going to talk about justice a little bit, and that makes people incredibly nervous, especially when you're talking about it in an equitable form, which here disgorgement by most courts' watches has been deemed to be equitable. I think in contract law it remains to be seen if that will be consistently applied that way, which means it will be a judge decision, and there will be that discretionary moment about the boundaries of it within contract doctrine. So there are a number of other conventional wisdom concepts within contract law, and those include that we are compensating the plaintiff and doing no more than that, for example. Disgorgement has been said to do something more than that, to potentially get into deterrence and punishment, and certainly if you look at the restatement of restitution, the commentary utilizes that language of doing something that we're very comfortable in property world, and we're very comfortable in tort world, we're comfortable in fiduciary duty world, but in contract world we don't talk as much about deterring. Certainly deterring opportunism is not something that traditional conventional contract thinking of late anyway has been thinking about. So one of the reasons I'm fascinated by the restatement of restitution in the U.S. is because it took many, many years to get to that moment. The restatement second failed, even though there had not been an update since 1937. The second was unable to get through passage, and so Andrew Cull took up the restatement third of restitution, and Nick mentioned that it passed in 2011. It took 13 years to get to that moment, and within it, it has this beautiful little section, section 39, that talks about disgorgement for opportunistic breaches of contract. And I asked Andrew Cole why isn't that something that ought to be in the restatement third of contracts? And he said, and I think he would go on record with this, that because that won't happen in his lifetime, that we won't get around to the restatement third of contracts. He had an opportunity to do it within the restatement of restitution. And to anybody who thinks about or knows about Mel Eisenberg's work, he's talked about how the restatement second of contracts specifically decided not to include that. They didn't believe the case law supported a disgorgement remedy for contract law, and Farnsworth himself was opposed to it. And he's written about that in his famous work on that topic. So I find it fascinating that now it sort of slithers and sneaks its way in, and it sneaks its way in the restatement of restitution. And I think most folks aren't paying too much attention to that, but I've been writing about it for a while, and there are a number of other scholars who've sort of picked up on it, that it seems to be in tension with some of those traditional sort of contract doctrines, as I mentioned, and there didn't appear to be strong case support for it. Yet the restators decided it was time to go ahead and point that direction. Nick mentioned the Blake case. Many know that the parallel to that in the United States is the Snap case. Snap was also a former CIA agent who had said in his contract that he would not, of course, write without pre-publication clearance. He did go ahead and write without pre-publication clearance, but technically the contract said he would not write classified information. He claimed that he didn't write classified information, that he was just writing without that pre-publication clearance. At any rate, my point in mentioning the Snap case is I think it shows something that the United States is not particularly, or the U.S. courts, including the Supreme Court especially, are not particularly interested in showing you their doctrinal logic, which I think Nick is calling for that, and it's a wonderful maneuver to ask courts to do that, and at least to get scholars thinking about it, because even though courts fall short, that's why we're here, that's why we're paid, and to do what we do, which is to critique courts. At any rate, the U.S. Supreme Court in that case really didn't have a right upon which they could get to the remedy they wanted. They wanted the remedy of disgorgement. They didn't really have the right type of breach. There was a contract that had been breached, but not exactly in the way that happened. There was a little bit of a potential fiduciary relationship, but it had ended. So they really couldn't properly get there, and the court, I think, admittedly knew almost nothing about unjust enrichment. They've shown that time and time again in a series of cases that I won't bore you with that are about ERISA doctrine. They don't have any idea how that doctrine really works, and if you go to any conference outside of the U.S., there's much attention being paid to the logic of unjust enrichment, whether it's doing corrective justice, what are the goals that it's trying to serve, and so I'm interested in, how are we going to do it here? In relation to my sort of larger themes, I care about the way in which remedies shape substantive rights. And so as I was listening to Nick, I was thinking, does that mean, am I sort of doing the cart before the horse? I'm trying to say that the remedy itself will shape the underlying right. He's, of course, saying, well, you need to have the logic of the right, and you have to have it connected between the two items he mentioned, which are the right that the plaintiff has shown and that the defendant's actual gain has to be tied and linked to that right. I think I agree with what he's saying, but at the same time, if you look at the courts that are now starting to extend this disgorgement remedy in contracts, they're not finding what he's talking about because they're just not looking that closely. It may be that we can look in retrospect at the cases that have awarded disgorgement, and I've begun to look at those in my most recent work on this, and they are starting to grant it for breaches of contract. And it's not that they never have before, but they never really said that's what they were doing. The only case that really in the U.S. is on books as doing that was Lauren versus DeCarolinas, which I know most of you are familiar with. The Gravel case, I think that does fit with Nick's thesis on sort of a quasi-property right to the profits that would have been made from that gravel that was removed and sold to a third party. But I need to think about that some more. But at any rate, so the U.S. courts that have been doing it, I don't think they're doing it too consistently, at least in the language in which they're describing it, in terms of the logic of disgorgement. But they are, if we look back at the cases, I think we might be able to find some of that logic. And many of the fights that have been going on within the briefs about the disgorgement cases, you have defendants arguing what we expected they would after the restatement, which is just to say the restatement's not law, it's not binding, it's only persuasive, and there's really no case support for this in the United States. That if you dig beneath the the restatement language, the black letter, all you're going to find is Blake and Snep, and those cases really weren't, one of them isn't United States, and the other one really wasn't a proper or didn't really spell out the contractual breach leading to that disgorgement remedy. So you see the defendants sort of trying to just maintain the strict territory of contractual boundaries. And so what I find fascinating is that as plaintiffs begin to argue, because of course they're going to like this remedy to some extent, as they begin to argue for it, you'll see the boundaries of that traditional territory of contract law expand. The remedy will start to, in reverse, sort of expand the right. I think that's a good thing, because then it gets, even though it's internally inconsistent with conventional contract wisdom, I think there's an unconventional story that has yet to be told about cases that were already doing things like this, that were finding quasi-property rights or were gearing towards tort law even if they disclaimed it. So overall, it's going to be coherent with a larger body of doctrine across. You're going to see, I think, blending between contracts and torts and property and perhaps other causes of action where you don't have the independent tort, you don't have the independent action, you only have the contract breach, but there's no reason why, if you find the same behavior and all you have is the contract breach, why you shouldn't be able to get to this disgorgement remedy if you were in the proper case. And so what I've been writing about now, and the reason why I'm looking at the cases that are calling for or not calling for disgorgement in the contract realm, is to see what is the proper case. And I found what Nick said to be fascinating. The restatement itself utilizes three words, or three primary words. I'm going to describe it in short form instead of long form. Those three words are deliberate, profitable, and basically an inadequacy type of element. The profitable is sort of a okay, check, you have that. We wouldn't be talking about this if the breach weren't profitable. We wouldn't be talking about trying to disgorge, so that's kind of met out of the gates. If you're asking for that remedy, you obviously think the defendant profited from it. The two that are interesting are deliberate and then the inadequacy component. I didn't hear Nick talk about, I'm interested as to whether he sees as part of the disgorgement logic, must you find some type of intent? Because there is an ongoing debate about that within the contract realm as to whether that should be prohibited, or can you really get into a, quote, opportunism and wrongfulness discussion. And the briefs that I've looked at so far, plaintiffs are arguing we don't have to show subjective intent, but if we show some combination of conscious advantage taking, which just means that they deliberately knew that there was a profit to be made, they knew that they had already signed a contract with us, and they're taking away our potential opportunity to have made that profit, then we should get to strip them. Of course, defendants are arguing, no, you're trying to do something improper in contract realm, and you don't have the case support for it. I have lots of cases I could talk about if you're interested as to how those are going. Most of them, where the courts are awarding it, they involve covenants not to compete, license agreements, settlement agreements. So I think again that those do fit in the theory that Nick is talking about. But I don't know what he would say about that intent element. There are a couple scholars right now that came out with a Michigan Law Review article, and that's Bar Gill and Ben Shahar, and they talk about intent shouldn't be a component at all. And they are purely interested in looking at sort of not one-to-one contracts, but instead like long-term behavior that shows a pattern. And if there's a pattern of misbehavior, even if by accident, that perhaps those are appropriate cases for disgorgement. I think their study is somewhat intriguing, but I think it's dangerous because they're trying to create an avenue to keep efficient breach fully alive and well. So I would much more be interested in something that's going to honor promise keeping, which is why I'm interested in having a disgorgement remedy available for these types of breaches. So as I mentioned, I don't think Nick talks about the intent. I'm interested to know where he is on that, if that should be a component or if that's something that's dangerous to get into in contract realm because it pushes us towards tort. And if we combine that mens rea plus that we're doing something more than compensating, again, pushing the boundary of conventional wisdom on contract, are we then starting to look a tad punitive, which we often disclaim doing. In Lauren versus DeCarolinas, the court specifically said, even though we're seeing willfulness, we are not punishing this defendant by stripping his gain. That's not what we're up to. And I think they did that because they didn't want to be in tort world and they didn't want to be in trouble for going outside the bounds, even though they really were. They were doing probably exactly that. Snap is certainly that. They wanted to punish him for breaching his pre-publication clearance agreement. So the other element that I think is what some courts are talking about, some of the courts are only talking about the deliberateness and whether or not the wrongfulness has been met, and if so, some of those courts are awarding this disgorgement remedy already underneath the restatement of restitution on a breach of contract claim. The other factor is what I'm calling inadequacy, and I've written about that because it is anachronistic. It is sort of reanimating the principle that we've tried to get rid of through merger. And when I say merger, I mean merger of law and equity and merger and civil procedure. We're trying to get away from these hurdles that are part of the equitable extraordinary remedy hurdles. That may be boring to you, but the point is it's back in the restatement of restitution, and it says the plaintiff can go for this remedy if they can show their other remedies are inadequate substitutes. And that ties, I think, directly to Nick's point about when he described the three, whether the right is particular or the right may be exhaustive or the right may be neither. In the example of the right may be neither, he used Acme as one of the examples there, or a chair of this type, but it's not exactly that chair. That means there is no quasi-property right, which means you would have no right to specific performance because you would not be able to show that that item is unique. You could show that you could get money to get a substitute for it, and that's exactly what's going on in these disgorgement cases. If they follow the restatement of restitution, even though I've written that it was bold in its language, Andrew Cole said, don't worry because it's narrow in application if they follow the restatement section, because it's only available if they can show monetary remedies will not do. Therefore, they'd have to show a quasi-property tie, which gets to Nick's piece and ties it all back together, and then they will be able to get disgorgement. So they have to actually show an exclusive right that's been violated, an exclusive contract or a non-compete, something like that, that shows that the entitlement, the substantive entitlement that they were anticipating from the contract has been stripped away by the defendant in a deliberate manner such that they should get to strip the defendant of those gains and get them returned. In closing, I think all of this is a good sign for contract law, albeit it's going to push those boundaries at the margins. I think it will push it in a way that it will align more with property law and tort law, as well as align with the Commonwealth, Israel, and many other countries who've already been moving on disgorgement as a provocative remedy that's available to plaintiffs. And they would go more broadly and let plaintiffs choose it in some instances, which are beyond the inadequacy narrowing that we're doing here. Thank you.
We do have some time for some questions, so I will pass the mic down.
You're all convinced.
If not, I have some. Sit.
I guess this is for Nick. I was really taken with the way you closed, and that was the explanation for the difference between the way positive and negative covenants are treated in your approach. I thought that really showed an imaginative way to justify a difference that might have been otherwise difficult to explain. I always kind of thought of the Acme case as meaning, I think as Caprice was saying there at the end, that the buyer in a sales contract is usually held not to have a title to the goods until they're actually delivered. And I'm told that in France it's different. I'm told that under French law, the buyer has title, so that if the seller then sells them to a third party, you have an ordinary conversion action, which the buyer would waive the tort and sue in restitution and get disgorgement there. And it sounded to me as if your argument about the appropriateness of restitution depended upon something like not quite a property interest, but in this notion of exhaustiveness. You were saying that particular item, and again, as Caprice was saying there at the end, that if you could get specific performance for it, you had a quasi-property interest in it, and that was what was justifying the restitution. Whereas I don't know under Section 39 whether that depends all that much on a property interest concept. I mean, you could have opportunistic breach under Section 39 possibly in a situation where the buyer might not be able to claim or the plaintiff might not be able to claim a property interest. But is that on point?
Yeah, that's exactly on point. So yeah, what I'm trying to do in a way is say something very abstract that unites both what we might think of as the proprietary context or contracts that give rise to property rights where title passes, and the distinction between a positive and a negative covenant, contracts for acts or services where we can't easily invoke any property context or idea of title passing. And a lot of people have been puzzled about why you would want to award disgorgement for breach of a negative covenant, but not for a positive covenant. And then on the property side, it seems more obvious that you should award it where some sort of object passes over to the other party under the contract. So yeah, this sort of very abstract logical scope distinction is meant to be a way of uniting all of that at a more abstract level in order to explain what's happening. Under English law, the position you described with title passing and then being able to sue for, say, conversion in the property torts and get disgorgement that way, I think it's reasonably clear that you can do that. My understanding of US sales law is not as good as my understanding of Commonwealth sales law, but I take it that Llewellyn tried to abolish the concept of title passing, so now we can't sort of talk about that. And so that makes things more difficult, and I just want to try to avoid the title idea because we get into all sorts of problems that way. But what I'm saying essentially aligns with what you're saying, I think. Yeah.
If I can just ask a quick follow-up, I actually had a very similar question, and my focus was on to what extent would the rule you're trying to develop coincide with the rule that said the plaintiff is entitled to disgorgement where the plaintiff would have been entitled to specific relief? Seems to me that I'm not sure I've thought through all the combinations, but in fact, your negative positive promise to perform services is a perfect example. I just wonder how close you can get to that, because where you can get specific relief, it's closer to the civil law world. It's not identical because of the title issue, but it's much closer.
Yeah, there's a really close tie to the availability of specific relief. The problem is that there's an equitable discretion that the court has whether to award specific relief, and it depends on all kinds of things, like, for example, the ease of supervision of the specific performance, or mutuality considerations, all kinds of other things like that. So there's various factors in the equitable discretion whether to grant specific relief that I think are irrelevant to disgorgement. But the idea that when you should get specific performance when you're entitled to some sort of unique or particular thing does more or less align with what I'm saying. Yeah.
Excuse my second year ignorance of the law, just a law student, but thinking about property law, what the gentleman was saying, that the examples that you gave us where disgorgement was actually given, I thought of myself, yeah, in those situations, the property owner, which the title did pass because for example, the example of the house, when they sold the contract was settled, the buyer of the house became an equitable owner of the property. And if he goes and sells the property to someone else and breaches that contract, yeah, I can see in that moment where the profits that are gained by that sale of that house would actually be entitled to the buyer of the property. And when I think in contract as a whole, and I think of two parties going into a contract, and the breaching party, if he pays the expectation damages to the other party, why should we award more damages than the expectation damages? That's what I see when you actually award damages or profits.
Yeah, so that. Like I said, that's a sort of classic case where I think disgorgement is available. There's some great Florida cases on this because you have a lot of real estate transactions going wrong down here. I just want to get away from the property versus contract distinction and explain what's happening without invoking the idea of title passing or property passing or anything like that, because I think you don't need to talk about that in order to explain when disgorgement is available across all of private law, property, contract, whatever. Should you just get expectation? Why should you get disgorgement rather than expectation damages? It's a great question, because often you'll have no sort of loss from the property case. Your expectation damages might be nominal, so why should you get the profit from someone selling the house that you've bought to another party? just because, or one way to describe this is just because that house is yours. And so when someone else profits by wrongfully dealing with what belongs to you, that action is itself wrongful. So how do we remedy that wrong? Well, one way to remedy it is to say that the plaintiff can take the profits that this wrongful action produces, and in doing that, I think the plaintiff sort of ratifies that wrongful action as if it were her own action, as if the defendant had performed that action on the behalf of the plaintiff all along, sort of like as if it were an agency relationship or something like that. So the plaintiff takes the profits. Now it's just as if this was my action all along, and so now it's no longer wrongful. That's my nutshell summary of why there's a normative basis for awarding disgorgement of profits rather than an expectation remedy.
Hey, I also think that's a great question, and that example that Nick is using of the homeowner scenario, I think that you have Judge Posner and others who've talked about that there's something different. There's a difference between opportunism and efficient breach, and they would, I think, style that one an efficient breach, and they would want to do exactly what you're saying, which is to cap at compensatory, and compensatory traditionally had, you know, the Fuller and Purdue, we're going to talk about those three versions, and we're not going to go beyond that. And so the only way to go beyond that, I think you have to do a reconceptualization of what it means to compensate, and that means you have to think about, well, what's the right for which, or the harm of what right that we're trying to compensate. And the only way you can get there, I think, is something like what Nick is saying, to look at it as the harm is something broader than what we've typically thought, and that it's not okay to encourage the seller to go ahead and go with the bigger, better deal after they've already made a promise to you, and as you said, created some type of equitable right already in the original purchaser, and that original purchaser should have had that opportunity to make those profits, or have lived in the house, or whatever it is that original owner wanted. But the only way to get there is to reconceptualize what it means to compensate. And expectancy, we've always thought was sort of, or it's been talked about as being the height, that's the default, that's the benefit of the bargain. But in many other countries, specific performance might be the preferred, and there are places where you can choose that, and so it would be along those lines that if you can get to that moment of whatever the requirements are. I think the requirements for specific performance in the U.S. are still a little bit overly burdensome, and they have all those sort of arcane equitable hurdles that you have to meet, but those include sort of showing something that looks like a quasi-property right, because you have to say that your monetary damages will not do, and that's why I think Nick was giving you there are situations where compensation would add up to nothing because you really wouldn't be able to prove that you'd been harmed in that way, because perhaps it's a fair market value or some other valuation. But the point is, in those cases, you would have a right to specific performance had they not already screwed it up. So disgorgement is a way to get you what you should have gotten had the timing all worked out, and they either asked you beforehand, or then you could have enjoined and gotten specific performance to make sure that property that already was kind of belonging to you actually did belong to you.
I think this has been a wonderful discussion. As an agency law teacher, I just want to advocate a closer look at the agency law parallels. Each year I teach the lingering duty of confidentiality on agents whose agency relationship has terminated. And it's true that it's true also for, and here's an overlap between what we've talked about, it's true for agents' duties with respect to the principal's property. Agents have duties with respect to the principal's property that includes constructive trust of all the profits that are obtained from the principal's property by the agent without the explicit consent, informed consent of the principal. And that also is a lingering duty that goes on afterwards. So there is a close tie there. There's also a line of agency cases addressing people who undertake agency-like duties who don't have them, an agency-type relationship, who don't have an agency relationship. And I'm not sure what the overlap might be there, but I think it might be fruitful to try. Great panelists, thank you. Should we give them another thanks? And thank you as well.